Welcome, y'all. I am the loud little ducky. In this video, we are going to go over a Ninth Circuit ruling that talks about law enforcement not being able to post mugshots online because it is too prejudicial to the defendant or to the alleged criminal or somebody that is facing allegations and the accused. And so we are going to go over that. Uh, David Gingras pointed this out in one of his tweets, saying that Laura Owen's mugshot being posted on Twitter was illegal because the Ninth Circuit said so. So we're going to take a look at that. And the Ninth Circuit includes Arizona, Alaska, California, Hawaii, Idaho, Montana, Nevada, Oregon, Washington, also including Guam and the Mariana Islands. That is the Ninth Circuit. So it goes for all of those areas. And of course, we have the cartoon version of Laura Owen's mugshot, which is just beautimous. But let's dive into this court thing and see if some random citizen posting a mugshot is considered illegal. So the United States Court of Appeals for the Ninth Circuit, this was a case of Brian Houston and other persons similarly situated, the class, versus Maricopa County of Arizona. Paul Penzone, the sheriff of Maricopa County, Arizona. Jane Doe from Penzone, unknown. And those are the defendants. And so it's appealing a case, and it was argued and submitted February 9th of 2024 in Phoenix, Arizona. It was filed September 5th, 2024. And it was before circuit judges Berzon, Hurwitz, and Johnstone. And the opinion is written by Berzon. So this is a fairly recent case and opinion. So let's jump into it. First, it says summary, and the automatic footnote is this summary constitutes no part of the opinion of the court. It has been prepared by court staff for the convenience of the reader. So, pretrial detainees. So, anybody that is pretrial and detained. The panel affirmed in part and reversed in part the district court's dismissal of punitive class action brought by Brian Houston, alleging that Maricopa County's policy of posting photographs and identifying information of arrestees on its mugshot lookup website violated his right to substantive and procedural due process and to a speedy public trial. The photographs posted on the mugshot lookup website are often gathered by other internet sites and thus remain available after they are removed from the county website, even if the arrestee is never prosecuted or convicted. So that's interesting. So anybody getting arrested for anything, once they have their mugshot picture taken, it would go to this mugshot lookup place and they would still keep it up. So if anybody like Googled your name, your mugshot would come up. And it basically just kind of shows that you've been arrested and what you were arrested for, maybe is on it, and, personal information and all of that. And you can still be an innocent person and have a mugshot out there. And so that's kind of prejudicial. It could be prejudicial in maybe getting jobs, uh, and things like that. But let's see what else they talk about. The panel reversed the district court's dismissal of Houston's claim that the county violated his rights to substantive and due process, which protects pretrial detainees from punishment before adjudication of guilt. To constitute punishment, a government action must harm a detainee and be intended to punish him. So by putting out mugshots before somebody has been convicted, um, is a violation of his due process rights, because it's he's saying it's kind of like an embarrassment and making him look guilty before he is found guilty while he's still presumed innocent because nothing has been proven. Just by having a mugshot, it makes him look guilty. Because some people think that just because you're in the guilty person chair, or you have been arrested and you've been charged, or you're sitting in a courtroom or in a trial with up against the state, that you must have done something wrong. And that's not always the case. It goes on to say that Houston sufficiently alleged that as a pretrial detainee, the mugshot lookup post caused him to suffer actionable harm, public humiliation, and discomfort compounded by reputational harm. Although Houston's mugshot lookup post was not a condition of his pretrial detention, governmental actions that harmfully affect arrestees pretrial can violate due process if impermissible, punitive, even if the county's assertion of transparency without more was a legitimate non-punitive government interest. No rational relationship existed between the goal and the county's gratuitous inclusion of at least some of Houston's personal information on its mugshot lookup post. Absent a rational relation between the post and the county's interest, an inference that the post was motivated by punitive intent was plausible, and so precluded dismissal. The panel affirmed the district court's dismissal of Houston's procedural due process claim because he did not show the county's mugshot lookup post implicated a cognizable liberty or property interest grounded in state law, nor did Houston's complaint state a plausible Sixth Amendment claim for violation of his rights to a speedy trial, because Houston was not prosecuted and had no trial. So this is a guy that has his mugshot out there. He was arrested for something, and now he has this mugshot picture out there, and they ended up not prosecuting him, and there was never a trial. So maybe they dropped the charges, maybe he was innocent, who knows what um, it was for. Uh, we might learn that in here, but he said it they didn't violate his right to a speedy trial because Houston was not prosecuted. So a picture is not going to violate your speedy trial right. Um, I get that it can be humiliating and things like that, and it can run live. So I can see the point. And people in town or people that know you might see it. Uh, Here we see mugshots all the time. There's like Facebook pages of that are dedicated just to our county's mugshots, and surrounding counties mugshots. They don't really have the information with them. It's just the mugshot itself, maybe the name. I'd have to go and look. But maybe if they just posted the mugshot and didn't say anything else about it, I don't know. But let's see. So the opinion from Berzon, Circuit Judge. The Maricopa County, Arizona Sheriff's Office posts photographs of arrestees on its website, accompanied by identifying information, for several days after an arrest. These identified photographs are often gathered by other internet sites and thus remain available after they are removed from the county website, even if the arrestee is never prosecuted, let alone convicted. The result is public exposure and humiliation of pretrial detainees who are presumed innocent and may not be punished before an adjudication of guilt. Our question is whether Maricopa County's policy of posting photographs of arrestees is constitutionally permissible. We conclude that it is not. So they are saying that these mugshots should not be posted on the county's website before they have been found guilty, um, or before a punishment phase. So they think that that's punishing somebody while they're still presumed innocent, which is, all right. So the background. Yeah, before the decision has been made. Okay. Background. Brian Houston was arrested by Phoenix police in January 2022 and charged with assault. See footnote 1. Because we are reviewing an order dismissing this case under Federal Rule of Civil Procedure 12b-6, we recite the facts as alleged in Houston's complaint, which we take as true. They have to view it in the light most favorable to the person. So it says, during Maricopa County's jail booking process, Houston's photo was taken and posted alongside many others on the county's publicly accessible mugshot lookup website. Next to the mugshot photo were Houston's full name, birth date, and an entry under crime type describing the category of his alleged offense. Pushing a more details button would have revealed Houston's sex, height, weight, hair color, eye color, and specific charges on which he was arrested. The post remained online for approximately 3 days. Pursuant to the sheriff's office regular practice, see footnote 2, it appears that an individual's mugshot lookup record remains posted for 3-day period following arrest, regardless of whether the individual is released from the county custody within that period. Houston was never prosecuted on the charges noted on the post, which were later dropped. Okay, so they dropped the charges against him. He was arrested for assault. They dropped the charges. Maybe the person that was assaulted decided not to go forward with the charges. They didn't want to cooperate anymore. To justify its mugshot posting practice, the county asserts that it promotes transparency in the criminal legal system. But the mugshot lookup page did not contain the names of the arresting officers, the division of the county police department responsible for the arrest, whether charges were pursued or dismissed, or the jail in which Houston was held. The mugshot lookup posts thus shed light only on the arrestees, not the operations of the sheriff's office or county law enforcement. See footnote 3. According to Houston's complaint, the county's post also contravenes the sheriff's office internal policies. Policy GF3 provides that personal identifying information, including birth dates, shall be redacted when criminal records are publicly disclosed. That policy emphasizes that birth dates have been declared confidential by law and thus constitutes personal information that must be redacted before public release of criminal records. So even in their policy, they should have the birth date redacted. The birth date is confidential. Maybe everything else might not be, but the birth date should be confidential, according to them. And they're putting it out there without the redaction. So they're violating their own policy. In May 2022, Houston filed a punitive class action under 42 U.S.C. 1983 and Arizona law against Maricopa County and Sheriff Paul Penzone, collectively the county, seeking declaratory relief, injunction relief, monetary damages, and punitive damages. Houston complaint alleges that the county's conduct violated Arizona's public law, the Arizona's Constitution's right to privacy, the Arizona law on intentional and negligent infliction of emotional distress, the Arizona Mugshot Act, due process under the 14th Amendment, and the Arizona Constitution, the 14th Amendment's Equal Protection Clause, and the 6th Amendment. Houston alleged that the county's mugshot lookup post caused him emotional distress and public humiliation, permanent damage, his business and personal reputation, and placed him at risk of identity theft, fraud, and extortion. I could see it burning a business if people looked it up. I could see it being humiliating. Maybe identity theft, fraud. I don't know about extortion, but okay. He asserts that at least one third-party website scraped his mugshot and personal information, and that the county was aware such practices occurred. Houston describes Maricopa County as a scraping hotspot, such as the notorious mugshots.com website purports to publish the booking photos and arrest information of close to 1 million Arizona residents, the vast majority, 834,000, from Maricopa County alone. That's a lot of arrestees. The county moved to dismiss the operative complaint. The district court granted the motion and denied Houston's motion for class certification as moot. Houston appeals seeking review of the Rule 12b-6, dismissal of his substantive due process, procedural due process, and the Sixth Amendment claims. We review the dismissal of those claims de novo. Let me make sure that I have the correct definition of de novo. That's not what I wanted. From the beginning or anew. Yeah, as if it's hearing it for the first time. Okay. And then it cites a case from the Ninth Circuit 2018. Substantive due process. Houston first advances a substantive due process claim. The due process clause protects pretrial detainees from punishment before adjudication of guilt. So before the decision of guilt or innocence. The constitute punishment. A government action must harm a detainee and be intended to punish him. So if it is there to harm a detainee or it's intended to like punish or like embarrass or whatever, which we're not supposed to do to innocent people, the government need not to expressly state to aim to punish. Instead, we assess punitive purpose by considering whether the challenged the challenged conduct operates as punishment or whether it is but an incident of some other legitimate governmental purpose. See footnote 4. An additional consideration is whether the government action appears excessive in relation to its stated purpose. On appeal, Houston argues only that no legitimate, non-punitive government interest exists, so we do not address the excessive action consideration. My throat is so wacky. Harm. Under the circuit's case law, Houston's allegation of harms by the county satisfies Bell's first prong at the pleading stage. In Demery, pretrial detainees challenged Maricopa County's installation and use of jail webcams on substantive due process grounds. Using in-jail cameras, the county publicly live-streamed footage of the jail's holding cells, bunk beds, pre-intake areas, and intake areas. Detainees were filmed throughout their detention, including while being booked, photographed, fingerprinted, and subjected to pat-down searches. In affirming a preliminary injunction, we held that Bell's harm prong was satisfied because exposure to millions of complete strangers as one is booked, fingerprinted, and generally processed as an arrestee constitutes a level of humiliation that almost anyone would regard as profoundly undesirable. Oh, so they were just having like a whole live stream webcam event of everything going on in the jail. Like a real live lockdown. Locked in, locked, whatever they call that show. Um, yeah, and if they're in a jail and not necessarily a prison, which means they have not gone to trial yet, or they're just in there for a night, they could be innocent, um, lots of different things. It'd be different if some of this stuff came out in a trial or after the person has been found guilty and like body cam footage is released and stuff like that. So that's interesting. Such online exposure significantly exceeded the inherent discomforts of confinement. Here, Houston alleged that, and we take as true in our review of the district court's dismissal, that the county's actions have caused harm and will continue to cause harm to him to suffer harm and public humiliation. As in Demery, the county's post on the mugshot lookup exposed Houston's image and the fact of his arrest to millions of strangers, able to access the sheriff's public website online, triggering discomfort that almost anyone would regard as profoundly undesirable. And unlike the live stream footage in the Demery, the distributed image of Houston identified him personally by name and birth date, making this mugshot lookup record immediately searchable. This exposure-based harm falls well within the one respect exceeds the humiliation and discomfort recognized as an actionable harm in Demery. So in Demery, you didn't have the identity of everybody that they were doing things. It was just a bunch of like arrestees on these cameras and going about their business. But on the mugshot, you are personally identified. So even if somebody looked up and watched that stuff, it might be hard because your name isn't mentioned and nobody knows who you really are unless you really search through it and stuff like that. Okay. The humiliation-based harm from the county's mugshot lookup post is compounded by specific reputational harms Houston alleged. Houston stated that the county permanently damaged his business and personal reputation by posting his mugshot and personal information. Demiri recognized that broadcasting we'll read that in a minute. Okay. We'll read that. Yeah, we'll read that sentence in a minute. Footnote 5. Notably, courts have been long recognized the harm in publicly circulating photographs of arrestees before trial. United States versus Kelly, Second Circuit, 1932, noting instructions not to make public photographs of pretrial detainees to prevent the misuse of the records. Another case recognizing the exhibiting a pretrial detainee's picture in a rogues gallery could be so serious a violation of her right of privacy as to justify judicial protection. There can be no public goods subserved by taking the photograph of an honest man for public display. A person is defamed by the taking and widespread dissemination of his photographs for criminal identification purposes before conviction. These cases suggest historical concern that without a particular justification for publishing an individual's mugshot, a general practice of doing so upon arrest constitutes an unnecessary and unwarranted attack upon a person's character and reputation. So, like, we can all probably understand where these people are coming from a standpoint if you're innocent and you've never been convicted. Because anybody can be arrested. I mean, you can get arrested for speeding if they wanted to. You could be arrested for a broken taillight. Like, there's lots of things. You can be misidentified. So you can be arrested for a bunch of different things. And if we are not the person that they are saying that the county or the state is saying we are, but that gets out online, it can be something. The thing is, when it comes to Laura Owens, to me, in her case, this mugshot is not a ruin to her reputation. This mugshot to me, doesn't necessarily cause her public humiliation because she has already suffered public humiliation at the hands of herself. And she was referred to prosecution. Stuff has already been found for her in a family case. So while she has not been charged, this mugshot is not making her reputation. It's not making it any worse, and it's not making it any better. They say that you can't really ruin somebody's reputation if they have a bad reputation already. Like, if they're already known for certain things, this isn't ruining that. Because you look up this woman's name before her arrest, she was well known then. Adding this mugshot to it doesn't change the story. She's still this same person with or without this picture. That's why I did a cartoon version. But, I want to hear what y'all have to say about this in the comments. And as we go through this and get to the end of it and fully what they decide, they've said it's unconstitutional, but to which part is unconstitutional? Are there things that you can do to make it better? Like if you did this, but you put, dismissed or not guilty, or, is there ways that you could do it, or what? Because I get being transparent with these things. We need to know what's going on. Um, because sometimes waiting, some of these cases, they don't go to trial for 7 years. And we're just not supposed to know that we have some crazy person possibly living among us because they haven't been to court yet. I I don't know. I like to know what maybe these crazy people might look like. Um, that's a hard one because I get the presumption of innocence, but at the same time, if is it we get to see the mugshot when they're done? When they have a new mugshot already? Because when they go to prison, if they go to prison, they get a new mugshot. So they have their jail one, and then when they go to prison, they get a new one. If they get transferred, they get another one. So we're just supposed to wait till trial's over? Is that really fair to society? To be unknowing about certain things. Maybe we should just know about the name of the case. How can we do this to keep the public informed, but also not violate a right, you know? So Dimitri recognized that the broadcasting of pre-trial detainees online increases exponentially the number of people observing detainees and also alters drastically the classes of people who can watch the detainees. So, to which the mugshot and the personal information posted on the county's public mugshot lookup page, an exponential number of viewers worldwide can access the site, including Houston's friends, loved ones, coworkers, employers, and others who both influence or are influenced by his reputation. ID at 1029 through 30. Houston's complaint thus makes sufficient allegations of harm to sustain his substantive due process claim. B. Government punishment. The second bell prong requires determining whether the county's mugshot lookup posts are intended to punish pretrial detainees. We must decide whether punitive intent may be inferred from the lack of rational relation to a legitimate non-punitive government interest. Yeah, is it meant to punish? I mean, maybe, because some of these mud shots be looking cray-cray. Um, Number one, condition of pretrial detention. Pretrial detention. As a threshold matter, the parties dispute whether mugshot lookup posts are conditions of pretrial detention or release. If they are, the county may rely on interests that assure the detainee's presence at trial or maintain security and order of the detention facility. They cite a 1998 Ninth Circuit Court decision. If posts are not conditions of pretrial detention release, those two interests are not pertinent, but others may be. We have previously observed that the release of arrest records is not a condition of pretrial detention. Demiri, so they're citing that again. We recognize that the challenged action in Paul v. Davis, distributing flyers with recent arrestees, names, mugshots, and crimes of arrest to local businesses, was not a condition of pretrial detention. Similarly here, the county's mugshot lookup post published shortly after Houston was taken into custody, and which likewise included his name, mugshot, and crime of arrest, is best understood as release of his arrest record that publicizes the fact of his arrest. The district court thus correctly determined that Houston's mugshot lookup post was not a condition of his pretrial detention. The district court was incorrect, however, in suggesting that if the government action challenged is not a condition of pretrial detention, it does not invoke the 14th Amendment's protections. Rather, governmental actions that harmfully affect arrestees' pretrial can violate due process if impermissibly punitive, whether a condition of pretrial detention or not. Legitimate government interest. The county has provided only one non-punitive reason for posting Houston's mugshot and personal information online, and they cited transparency. In the district, footnote 6, in the district court, the county argued that publishing mugshot lookup posts both increases transparency. It's been a long day. In the criminal justice system, and meets the Arizona Public Records Law requirement that all public records shall be made available for inspection. On appeal, the county does not press statutory compliance as a government interest. As an appellee waives any argument it fails to raise in its answering brief, we consider only the county's assertion interest in transparency, not any. So they have moved that to the next page as well. So we will move on to that. Transparency statute-based interest. Then continuing on here, it says dispels the specter of government punishment. Arguments about transparency, quite a vague concept, require context. We cannot credit a transparency justification without evaluating what information is at issue, to whom such information is being revealed, and the purpose such disclosure serves. After conducting such an examination, we conclude that a mere assertion of transparency interest does not establish a legitimate governmental objective requiring dismissal of Houston's complaint. The complaint plausibly asserts that the information the county posted about Houston is detailed and highly personal. The audience is global, as the information posted is accessible to anyone with an internet connection. The government's version of transparency suggests that the public disclosure to any audience, however broad, of any information about what a government is doing is justified for its own sake. Not so. To defeat an interference of punitive intent, the county must articulate some specific concept of transparency that justifies public disclosure of this information to this audience. It has not conceivably done so at this stage of the case. The case the county cites as demonstrating the legitimacy of transparency interest actually supports the opposite conclusion. In those cases, transparency was invoked not in a vacuum, but in the context of furthering public safety, an interest the county does not mention in its arguments about transparency. Well, they should have. They definitely should have, because I would have mentioned that. I'm not a lawyer, but I would have mentioned for public safety, for public's knowledge, the transparency of that and for that. But let's read on to find out what else. Smith v. Doe, for example, concerned a challenge to a sex offender registry statute that made public information about convicted sex offenders. In that context, Smith framed transparency as essential to maintaining public respect for the criminal justice system, ensuring its integrity and protecting the rights. Public, public request for the criminal justice system, ensuring its integrity and protecting the rights of the accused, emphasizing that the most significant factor supporting exposure of information at issue in the case before the court was public safety, which is advanced by alerting the public to the risks of sex offenders in their community. Yes, that's why we should know about that. But we are the thing is with that, we are notified about them being sex offenders after they have been charged and actually convicted of the sex crimes, not before. Um, so that argument, I get the public safety thing, but the way we find out about those is after, not before, like the mugshots of arrestees. In Doe v. Garland, Doe challenged an FBI press release that included his name, employment history, charge, and guilty plea. Citing Smith, we recognize public safety and system transparency as legitimate, non-punitive aims. Notably, Smith and Doe both arose in a post-conviction postures where the notion that transparency is public safety promoting is bolstered by the fact of a previous conviction. Here, in contrast, Houston was arrested but not prosecuted. He had not been convicted when the county published its post, and he never was. Paul v. Davis invoked transparency as a pertinent government interest in context of the government's public circulation of information about arrestees. But again, transparency in Paul was closely linked to public safety concerns. In Paul, police distributed flyers to local businesses with Davis's name and photo after his arrest but before trial, identifying him as an active shoplifter. The Supreme Court emphasized that the flyers were intended to alert local area merchants to possible shoplifters during the holiday season to inform their security personnel. As in Smith and Doe, the government's conduct was justified not by its indistinction concept of government transparency, but by the transmission of information to promote public safety. The challenge distribution of Davis's personal information was limited to businesses with specific interest in that information to avoid being robbed or to report a robbery. The county has not asserted that its untargeted broadcast of Houston's arrest record across the world promotes public safety in Maricopa County, nor does the county offer examples where transparency alone, absent a connection to public safety, has been accepted as a legitimate non-punitive interest for bail purposes, much less a pretrial context. The county's lack of clarity and support in the present context for its stated goal of transparency undermines its contention that mugshot lookup posts do not punish pretrial detainees. Okay. Rational relation. Number 3. Even if the mere assertion of transparency were in this context broad enough to reach beyond public safety concerns, the county's policy is not rationally related to any such interest. Nowhere does the county explain how posting specific, highly personal information about individual arrestees online, including here, Houston's image, birth date, full name, appearance, details, and charges, furthers any transparency interest. In Demery, We held that live streaming pretrial detainees online was not rationally related to transparency about Maricopa County's actions. Identified the county's stated interest in transparency as a government issue in empowering and informing Maricopa County voters. Um, so I showing them, here's the day-to-day actions of how the jail works, how we do this, how we do that. You can see what we're doing. You can see that we're doing everything good. Um, although I've heard some bad things about Maricopa County Jail. Um, well, Lori Vallow doesn't have much to say about it, at least the women's part. But, you know, there has been things that are shown and stuff like that. Like it could be like a documentary piece, but yeah, the live streaming people that haven't even gone to trial yet might not be great. Um, but we held the broad public exposure of live streaming, the arrest process, and pretrial detention was not rational connected to goals associated with educating citizenry of Maricopa County. As Demery, Houston's mugshot and personal information were posted on the broad spectrum of the internet, the global post public access, and he was subjected to broad public exposure. To the extent the county's reliance on transparency has been unarticulated educational dimension, no reason connection exists between displaying images of Houston to internet users from around the world, accompanied by personal identifying details, and educating Maricopa County residents about how the government generally, or the criminal legal system in particular, operates. One could perhaps derive from mugshot lookup post statistics about the crimes for which people are being arrested in Maricopa County, but personal information about the individuals being arrested is extraneous for that purpose. Like they could post stats and graphs and be like, okay, we arrested this many stalkers and this many, burglars and things like that. They could just show that and do a statistics report, I guess. Um, Nor do the posts contain geographical information that might be useful in figuring out where crimes are occurring. Yeah, if they're just happening within the county, it's not showing you which city in that county or which road, but arrest reports do. And we get those. But there's been some backlash against even some, like we used to read like arrest reports in the newspaper. That was a funny section to read even as a teen. I would read them and it would have the names and stuff, or you would be like looking on that street and you're like to figure out where you saw cop cars earlier that week, and so you're like, oh, that's what was happening there, or oh, I know that person. Um, yeah, that's the shady house on the block or whatever. And it kept us informed, but I've seen people do that in the like internet social media sphere, do the same thing that the newspaper was doing, and then people are like, how dare you put their names out there? Like, you should leave the names out of this. So, times are changing, and I guess we got to be a little bit more careful for certain situations. Um, in short, even as raw data, the posts do not provide useful information for understanding criminal enforcement activity in Maricopa County. Publishing Houston's mugshot and personal information online is not rationally connected to the county's transparency justification for other reasons as well. The mugshot lookup website shows pictures and personal information of recent arrestees for a 3-day period after an arrestee is booked, after which an individual's mugshot lookup post is removed from the website. If there is a legitimate interest in posting Houston's arrest, his arrest record online, such interest is surely frustrated by the brevity of the window during which that information is publicly accessible on the government's website. Moreover, when evaluated based on government transparency, the county's mugshot lookup post for Houston is both over-inclusive and under-inclusive. First, Houston's post includes a significant amount of personal information unconnected to any theory of government transparency. What is the public's interest? For example, in publicly disclosing Houston's weight. So, two, with the other personal information, including his birth date, height, eye color, and hair color, the county nowhere purports to show, much less succeeds in showing, why this level of granular detail about Houston's body and personal information rationally furthers an interest in government transparency. So, okay, like we take the birth date off, or maybe just have the year um, or their age, maybe don't have the rest of it. On there, because why is that public interest? But once again, do we have to wait 7 years for a trial to play out possibly and then be like, oh, if I would have seen that mugshot, I would have been able to be a witness and say that guy did this to me too. And seeing that mugshot, it triggered the thing in your brain and you're like, that's him or that's her. Um, and then that person could become a witness, or they could talk to the prosecution or the state and say, you know, that guy was arrested for assault. That same guy assaulted me at the Walgreens on Tuesday. You know, I didn't know who he was. I didn't know his name. I'd never met him. Um, but seeing this picture, I know that's who it is. And that person's going to have to wait 7 years to possibly see this mugshot if he's found guilty. But he wasn't charged in this case. But maybe if he had done it to somebody else, that person sees them and maybe they get charged in that case. So it does help the public. So I don't really know fully what the answer is here, but um, there are pros and cons to it. I get it. Um, and in this day and age, you can't really wipe things off the internet. Um, Once they're on the internet, they can live on forever. So it's not as easy to scrub things as maybe things were before. Um, Telling Houston's mugshot lookup post also omits relevant information. The post includes no description of government activity that would promote understanding of the county's system for apprehending, prosecuting, and convicting criminals. Houston's published arrest records left out a range of pertinent details, including the names of the officers who arrested Houston, the location of his arrest, the arresting agency, in this case, the Phoenix Police Department, not county officials, the jail in which Houston was held, and whether charges were ultimately pursued. The county provides no rationale for excluding from Houston's post information about government conduct that would have provided insight to the county criminal's legal system, while including significant personal information about Houston woefully irrelevant to that goal. So yeah, I can agree. If you're going to put that information out, put where you're at in the case. You know, he's he's still here, it's being pursued, case dismissed, dropped, found not guilty. Like, I can see adding that to it to be more transparent about things in the process. In short, even if transparency is a legitimate government interest, no rational relationship exists between the goal and the county's gratuitous inclusion of at least some of Houston's personal information in its public mugshot lookup post. Absent a rational relation between the post and the county's interest, as articulated at this stage of the case, an inference that the post was motivated by punitive intent is plausible and so precludes dismissal. The second prong of the Bell test is therefore satisfied. We conclude that Houston adequately pled a substantive due process claim under Bell and Demery. Okay, so then they go into procedural due process. A Section 1983 claim based on procedural due process has three elements. 1, a liberty or property interest protected by the Constitution. 2, a deprivation of the interest by the government. 3, lack of process. As Houston has not properly pled a constitutional protected interest, his procedural due process claim fails. Okay. The Federal Due Process Clause protects certain state-created liberty interests. The procedural guarantees of the 14th Amendment apply whenever the state seeks to remove or significantly alter the protected status of interest, initially recognizing and protected by state law. Houston does not invoke a federal interest to support his procedural due process claim, so his claim turns on the existence of state-created liberty interest. Not every state law respecting privacy will create a liberty interest protected by the Constitution. State law can create a right that a due process clause will protect only if the state law contains substantive predicates governing official decision making, and 2, explicitly mandatory language specifying the outcome that must be reached if the substantive predicates have been met. The lodestar of Marsh's two-pronged inquiry into a state-created interest for procedural due process purpose is thus the parameters of the relevant state law. Houston argues the Arizona Supreme Court recognizes liberty interest in the privacy of personal information, including birth dates. And then they cite some stuff. And that citing held that school districts should refuse a news station's request under Arizona's public records law for records containing public school teachers' birth dates. But Scottsdale Holding concerns what information a government entity may refuse to disclose after public records cannot directly translate into principle that such information is protected from disclosure as private should a government entity choose to reveal it. Footnote 7. This different context is why the district court's focus on availability of a special action under the public records law is inapt. Such an action is unavailable because Houston, unlike the news station in Scottsdale, is not requesting records. Okay. We need not pursue further whether there is any basis in Arizona law for substantive privacy-based interest in non-disclosure of one's birth date. In any event, Houston's procedural due process claim fails. The Marsh inquiry's second prong, which requires mandatory language directing a certain outcome if specified substantive conditions are met. The statute in March straightforwardly removed government discretion with its mandatory ban on reproducing autopsy photos without court approval or particular exemption. In contrast, Scottsdale does not contain the requisite explicitly mandatory language specifying the outcome that must be reached if the substantive predicates, which is inclusion of an individual's birth date in a government record, have been met. Quoting James, Scottsdale held that the school districts were not required to disclose the requested information under the public records law, but nowhere suggests that the districts were forbidden from doing so voluntarily. Instead, Scottsdale noted that if privacy interests are sufficiently weighty, the state can properly refuse inspection of public records. So, unlike the autopsy statute in Marsh, neither Scottsdale nor any other cited authority specifies the outcome that must be reached once the asserted substantive predicate giving rise to privacy interest, a record's inclusion of someone's birth date, is met. The outcome controlling mandatory language required under the second Marsh prong is entirely absent. Accordingly, Houston's complaint cannot satisfy the Marsh inquiry. The complaint therefore fails to demonstrate the existence of state-created liberty interest in the privacy of one's birth date, cognizably under the Due Process Clause procedural protections. To the extent Houston's advances a second theory of liability based on reputational harm as a denial of procedural due process, he again has not plausibly pleaded a claim. Procedural due process protections apply to reputational harm only when a plaintiff suffers stigma from governmental action, plus altercation or extinguishment of a right or status previously recognized by state law. Here, Houston was pled stigmatic harm to his reputation, but for reasons described above, has not shown the county's post distinctly altered or extinguished a privacy interest in his birth date recognized by state law. In sum, Houston was not demonstrated that the county's mugshot lookup post implicated a cognizable liberty or property interest grounded in state law. He therefore cannot make out a 1983 procedural due process claim. The district court correctly dismissed that claim. Okay, Sixth Amendment. Nor does Houston's complaint state a plausible Sixth Amendment claim. He alleged the county punished him in violation of his rights to a speedy public trial by posting his personal information on its mugshot lookup page before an adjudication of guilt. As Houston was not prosecuted and had no trial, no speedy trial right was violated. Yeah, that one's pretty much... I can't believe that they even cited the Sixth Amendment. The Speedy Trial Clause is largely concerned with preserving a defendant's ability to present an effective defense. The Sixth Amendment also protects the right to trial before an impartial jury. When charges are dropped, the speedy trial guarantee is no longer applicable, as the individual no longer faces a public accusation. Any harm from delay incurred before charges are dismissed falls instead under the ambit of due process clause. Houston's charges, as he acknowledges, were dropped soon after the arrest, and he cites the case as recognizing a right to be free from undue public accusation, even if ultimately vindicated. But Loud Hawk is to the contrary. In the case, 90 months passed between Loud Hawk's arrest and indictment. CID at 304. Loud Hawk stated that although the Sixth Amendment protects an accused person against undue and oppressive incarceration prior to trial, such protection no longer applies if charges are ultimately dismissed. Once an individual is no longer the subject of public accusation, the Sixth Amendment is not posit. Because Houston has no charges outstanding, his Sixth Amendment claim is not viable. And I think he wasn't quoting it for the speedy trial purpose. I think he was trying to quote it for the right to an impartial jury, in which he didn't go to trial, so that doesn't matter because he's not going to be in front of a jury, so it's not going to matter because there is no jury to be impartial. When it gets to the Owens case and a jury, this video is a hot mess. I am so sorry. When it gets to the Owens case and her jury, if she does not make a plea deal, which she should, then the jury will be asked if they know anything about any of the witnesses, if they know any of the witnesses, if they've heard anything about Owens v. Eckerd, if they've seen anything on it, if they've watched any YouTube on it, if they've, anything that relates to this case, do they know anything about it? The jury people that come in when they're doing the voir dire, they will be asked that because it's been publicized. I don't know how big it actually is there, but it's kind of big on this corner of the internet. I mean, the mainstream media didn't want to say crap about it for years. So her defense team will get to strike for cause, not using one of their preemptory strikes, but those people that know anything about this case or have formed an opinion on this case or know anything about her or is a fan of Clayton Eckerd and watched his Bachelor season, those people will probably just be dismissed. The judge will say, nope, we're not going to use you. So they're going to have people who don't know about her or maybe Clayton Eckerd or any of this. People who don't watch The Bachelor. Because whether Gingras or Owens or her family think that everybody in the entire world watches Bachelor, knows everything about The Bachelor, and that everybody in the entire judicial system is against her because Clayton Eckerd was the Bachelor for a season, and there's been several people since him. And she's going to claim jury bias if she loses this case. They were blinded by Clayton Eckerd's fame and all that. But she's going to be able to have an impartial jury. So anybody that has maybe seen her mugshot or seen anything about this story that we cover in our corner of the internet, they're not going to be on her jury. So her Sixth Amendment right, whether her mugshot is out, in my opinion, or not, is not going to violate her Sixth Amendment right. So if she tries to pull this Sixth Amendment right violation, it's going to be BS. But in conclusion, the state may not punish pretrial detainees without an adjudication of guilt. Houston plausibly pled a substantive due process claim against the county based on pretrial punishment. We therefore reverse the district court dismissal. We affirm that the court's dismissal of Houston's procedural due process and Sixth Amendment claims, affirmed in part, reversed in part, and remanded for proceeding consistent with this opinion. So I am wondering, this was just them, and they're like, okay, now that we've made this opinion, y'all need to decide things in this case. they remanded it back down to the other court. So we may have a part 2 about how this ends up. Like, what are the rules for this? Because I would like to know the rules behind the mugshot stuff. This just tells us that it did violate his constitutional right by posting it on mugshot lookups or their site for 3 days. I know that we did not get this off of Maricopa County's site. They did not post the mugshot. I know that's not how her mugshot was given. So this is just an open discussion about what do you think about mugshots being posted online. This did not prove whether David Gingras was correct about it being illegal or not. It just says that they shouldn't post it with all this information on Mugshot Lookup or the county's Mugshot Lookup page so that it can't be disseminated amongst places where people go to look up mugshots and do backgrounds. So Gingras has still not been proved right on this. It's just an opinion that can be cited and used in other cases, and possibly we might see this case cited in an appeal for Laura Owens, but we shall see. I'm going to try to get to the bottom of this, and I will keep you in the loop. But I will see you guys in the next video.